Good morning, everyone. I am going to share my screen um, so that you can see my slides. Can everybody see that?
Yes.
Okay, great. So this morning I'm going to talk about a couple of things. We're going to talk about reasonable accommodations under the ADA, and we're also going to talk about harassment. Those are the two topics I was asked to present on. And I'm just going to present some general information that I thought employees could use, but feel free to ask any questions that you may have about either topic or anything else that falls under the compliance area. So we'll go ahead and get started. So reasonable accommodations under the ADA. So that's under the Americans with Disabilities Act. And the Americans with Disabilities Act is a law that does two primary things. The first thing it does is it prohibits employers from discriminating against individuals that have disabilities. And that's in all of the employment aspects: job applications, hiring, firing, promotions, your pay, training, and anything else we would provide to an employee. The other thing it does is it requires employers to make reasonable accommodations for employees that may have disabilities, provided it wouldn't impose an undue hardship. So those are the two things that we're required to do under the Americans with Disabilities Act. In addition to the Americans with Disabilities Act, Columbus City Schools actually has a policy in place that basically mirrors the Americans with Disabilities Act and commits to the same things. It prohibits discrimination against any employer applicant based on that individual's disability, and then again states that we will provide reasonable accommodations to a person who has a disability unless it would impose an undue hardship on the district. So we use a lot of terms in those two things. Those brief statements kind of use a lot of terms that have qualifying definitions. So like I said, the first thing that they do is they prohibit discrimination. So discrimination basically is just treating somebody differently, less favorably than somebody else because of their membership in a protected class. And in this case, it would be because the person has a disability. And then a reasonable accommodation, those are adjustments or modifications that an employer would provide to help someone with a disability enjoy equal employment opportunity. So that can include things like acquiring or modifying equipment or devices. So for example, if you needed a captioned telephone, that is something that we could purchase for you. It also includes making facilities accessible. So if we need to add automatic door openers to a building, if we need to add grab bars in the bathroom, it would be those types of things. And then it also offers for providing other workplace adjustments, which could be scheduling adjustments or something like that, depending on what the employee may need. So what's a disability? So a disability is basically a physical or mental impairment that substantially limits one or more major life activities. And so a person who has a disability either has a physical or mental impairment that substantially limits one or more major life activities, or has a record of such impairment, which means it could be somebody who has cancer, but the cancer is in remission, or somebody who's regarded as having a disability, which means the person may not actually have a disability, but the employer, for whatever reason, believes that they do and treats them differently based on that belief. And then the term qualified individual with the disability is used a lot when we talk about accommodations and disability discrimination. And that just means that the person is qualified for the position, either the position that they have or the position that they have applied for. So in defining disability, we talked about the impairment substantially limiting a major life activity. And substantially limiting just basically means that person is significantly restricted in their ability to do that activity compared to the average person in the general population. And then major life activities. Major life activities would be things such as walking, seeing, hearing, eating, sleeping, standing, lifting, bending, all of those things on the list there, thinking, concentrating. And it also includes major bodily functions. So your digestive functions, your brain function, your respiratory function. So all of those things can be considered major life activities. And then we also talk about providing accommodations provided it wouldn't impose an undue hardship. An undue hardship basically would be anything unduly expensive or substantial or disruptive that would alter the operation of the district. So one of the things that I thought would be helpful for you all to know is how to request an accommodation. So we basically have an online request form available to employees who might need a reasonable accommodation. Anyone who has a medical condition and they need some assistance in performing their job duties can request an accommodation. If you were to go to the Columbus City Schools homepage and across the top, you'll see all those selections. And if you go to departments, you can either click on departments or hover over departments, and you'll have an option to select compliance. If you go to the compliance page, on the left-hand side, you'll see a list of laws that fall under the compliance office. And one of them is the Americans with Disabilities Act. If you click on that, it'll take you to the screenshot that I have below that says to request a reasonable accommodation, please click here. And if you click there, it'll take you to our online request form. You can fill out that form to request an accommodation. So when you access the form, we would ask that you complete and submit the form. And once you do that, basically it generates 2 emails for you. One email will provide a copy of the request that you made to you for your records. The other one is a letter addressed to your doctor, and we do ask for your doctor's information on the form. And it's a letter addressed to your doctor that basically enables us to get some information from your doctor about your medical condition, so we know how best to assist you. It gives your doctor the opportunity to give us some information about your medical condition, how it impacts you, and what sort of things they would recommend that we provide to assist you in doing your job duties. And then there is a physician's questionnaire. That's what we would be asking your doctor to fill out. It is available online as well. When you access the online request form, in the instructions of how to complete that form, we do make a link to the physician's questionnaire available there. And then that email that you get of your request for your records, we also send you a link to the physician's form in that email. So those are the 2 places that you'll get the link to access the form. It's basically a Word document that you can either save and send to your doctor, email, or however your doctor prefers to get such forms, or you can print it and send it to them. We do ask that you have your doctor complete that form and complete it as timely as possible so that we can get assistance to you as quickly as possible. And that information, the information the doctor provides, will help us do that. So you can send the completed questionnaire back to us. You can always provide it in person. You're always welcome to do that, or you can mail it to us, or you can email it to us. And unfortunately, we do not have a fax number. A lot of doctors' offices would like to fax the form back to us, but we currently do not have a fax number for them to send it to. But if you're comfortable, you're welcome to scan it and email it to us. So once we have your information, the information that you provide on your request form of what you need, and the information that your doctor provides about your condition, how it impacts you, and what they would recommend we provide, we're going to talk to you about it. We're going to try to understand how we can help you. And we're also going to talk to your supervisor and make sure that anything that we propose will also work for your supervisor. We don't want to make assumptions about how your work unit operates. So we want to make sure that we understand how everything works, so that we can make sure whatever we're doing is going to work for you, is going to work for the rest of your, for your supervisor and your work unit, and not be disruptive. So we may talk to you about what your job duties are, so that we can understand better how any changes might impact the job duties you perform. We're going to talk to you about how your condition impacts your job duties, what kind of limitations you may be experiencing that we can assist with. And then we're going to talk about what we can do that's going to help you perform your job duties, and explore some options and see what's going to be most effective. But we do want you to keep in mind, we may settle on something that isn't exactly what you asked for, but will work for you. And I will provide just a couple of examples of that, so you kind of understand what I'm talking about. So for example, if somebody has a condition where it would be helpful for them to have noise canceling headphones, that is something that we could potentially provide for you. But if you request the most high-end expensive pair of headphones, we may not purchase that particular pair, but we will purchase something for you that will work. There might be some other things where we come to an agreement on something that's slightly different than what you asked for, but still addresses the concerns that you have. For example, another example would be, let's say you have a condition where being in an air-conditioned building would be beneficial to you. And the building that you're currently assigned to does not have air conditioning. So your request is for a transfer to an air-conditioned building. That may or may not be something that we can do for you, but what we may be able to do instead is purchase some sort of personal air conditioning equipment that you would have, so you still have that air conditioning, but maybe it's not exactly what you asked for, which was the transfer, but we still get you what you need to assist you in performing your job duties. So that's just kind of a couple of examples where you may not get exactly what you asked for, but we will still try to find something that will work for you. And we do ask that if you need an accommodation and you engage in this process with us, we ask that you engage in this process with us. They do call it an interactive process, and we hope that that's what it is. We want to get you what you need in a timely manner. Obviously, if you're telling us that you're having some difficulties and you need some assistance in performing your job duties, we want to provide you what you need to help you as quickly as we can. So it's always helpful for us to hear from you if we have questions, for you to respond to our questions timely. Same thing, if we need information from your supervisor, we ask them to respond timely, just to make sure that we are continuing to interact, talk it through, make sure that we get you what you need, and what we're able to provide as quickly as possible so that you have the assistance that you need. So that's the basics for that section. So if anybody has any questions, you are welcome to ask them in this forum. If you would prefer not to, you always can contact us. I have our contact information displayed on the screen. You're welcome to give us a call. You can talk to myself, or Reggie Smith is our ADA coordinator. You can speak with him as well. You can call or email any questions that you may have, and we would be happy to assist you. So I'll pause for a second to see if there are any questions, and then we'll move along to harassment.
Awesome. Yeah, I had a couple comments that this will be very helpful information for the classrooms. So thank you again, Aisha, for presenting this information. I also had someone say that this is a touchy subject. So you want to kind of talk about that as far as it being a touchy subject. There was a response that it's really good information to know and be educated about it, but what has been your experience that makes it kind of touchy?
Well, I'm not exactly sure what, what the person is directly speaking about, but I do know it can be twofold. It can be difficult sometimes for people to ask for assistance. So I know that has been a difficulty that we've seen on occasion. We definitely have employees who, are adamant that they can do their job duties and they do not need any assistance. But there may be people around them, concerned and asking them if they need some sort of help. And that can be challenging. We do provide assistance with not just physical disabilities, but also mental disabilities. And so it definitely can be difficult sometimes for people to ask for help, especially knowing that we're not going to tell your supervisor what your medical condition is. We're not going to tell them why you're asking for an accommodation. But we will need to discuss with them what you're asking for and if that can be provided. So I know that can be difficult for people because we're going to be discussing, with the supervisor, hey, can we provide so-and-so, such and such? So that can be difficult, having to disclose that to your employer and having your supervisor be aware that something is going on. So I know that can be difficult for people. And then again, I think sometimes, I'm sure people have experienced some difficulties with their supervisor and supervisor expectations and, not understanding, and kind of being very rigid. And I will say, I will provide an example from my previous employer, actually. We were able to do flexible work schedules. That's something that's a little bit more difficult to do in this environment, but we were able to do flexible work schedules in that environment. But we did have a supervisor that was very rigid about their employees' start and end times, and didn't want them to be even 1 minute late. And we did have an employee who had a condition that a flexible start time and a flexible window was very helpful to that employee. And the supervisor was difficult to come around to providing that accommodation. But as an employer, we are obligated to do that. It was definitely something that could be done. It did not disrupt the function of that work unit. And so it was something that we did do for the employee. But I know people are concerned, is my supervisor now going to treat me differently, because now I have this accommodation, and especially if they're not happy about it. And they cannot do that. This is something that we are obligated to provide for you as an employer, and they cannot discriminate against you because you have a disability. They can't retaliate against you for asking for assistance. So just want to make sure everybody is aware of that. like I said, if you are having difficulty and need some assistance in performing your job duties, we will see what we can do for you.
Awesome.
Were there any other questions, comments?
Yes, I have two more quick questions on this subject, and then there were a couple that kind of goes into the harassment. But one of the questions early on was about the harassment form not being online anymore. It looks like there's only something for bullying and harassment for students, but not staff. Has it been moved, or is it just not available online anymore? And then the other question regarding accommodations was if a person can't qualify for FMLA, does ADA accommodation, is that an option?
Okay, so really quick, in the harassment section that's coming up, I will tell you how to access the complaint form, if that's what you're asking about. It is available online, so I'll tell you how to navigate to that. And then FMLA and ADA are different. So FMLA, it enables you to take leave, either intermittently or for a period of time. What accommodations typically do is they help you perform your job duties when you're at work. And so it basically depends on what you need. It's not necessarily, well, if you don't qualify for FMLA, you can get an accommodation. It sort of depends on what you need. So like I said, for example, if you're hard of hearing and you need a caption telephone, we can purchase you a caption telephone. If you have low vision and you need some kind of magnification for your computer screen, we can purchase that. So those are things that don't really have anything to do with leave. So it sort of depends on what the condition is and what difficulties you're having and what you need. So we try to do them on a case by case. So I hope that answers your question. But feel free to contact us and we can talk through your specific concerns if you would like.
Thank you so much.
Okay, is there anything else on accommodations?
I am
If not,
scrolling through and I don't see anything. If there is another question, if someone thinks about anything, throw it in the chat and we'll incorporate it.
okay, sounds good. So moving along to harassment. And our complaint process actually covers discrimination, harassment, and retaliation. But I was specifically asked to talk about harassment today. So that is what I'm going to focus on in this part of the presentation. So there are anti-harassment laws. I did not list all of them here because there are multiple and they kind of cover different categories. But I did want to share with you that Columbus City Schools has an anti-harassment policy. And it basically says, we want to maintain an education and work environment that's free from harassment. And, we expect students, administrators, teachers, staff, and all school personnel to share the responsibility in avoiding, discouraging, and then reporting harassment. So I did want to share that with you. So one of the things that I want to highlight is who's protected under these anti-harassment laws. So in the civil rights area, which is kind of the area that we're talking about, for harassment to be unlawful, it has to be conduct that's based on a person's membership in a protected class. There are occasions when, we hear, and again, not just here, but my previous work experience, that you have a supervisor or a coworker that's just mean, and they're mean to everyone. And I know oftentimes people say, well, that person is harassing me. And I definitely understand where the person is coming from when they say that. But for it to be covered, by our anti-harassment laws, anti-harassment policy, the conduct has to be based on a person's membership in a protected class. So there are a number of protected classes that are covered under Columbus City Schools policy. So I'll go through them for you. So age is covered. Age covers those who are 40 and over. Race is covered, and that means if you're treated differently based on your race, whatever your race may be, it isn't any certain races that are the only ones that are covered, it's everyone. So race is covered, color, national origin and ancestry, sex or gender, sexual orientation, gender identity or expression, religion, as we talked about in the first section, disability, military status, familial status, and genetic information. And then our policy also says in any other legally protected category. So in the event that laws change, or what we consider is covered under a particular law may change, and that could potentially bring additional categories in. For example, Title VII of the Civil Rights Act of 1964 prohibits discrimination, harassment based on sex or gender. And the courts are now interpreting that to include sexual orientation and gender identity. So, excuse me, what is harassment? So harassment is unwelcome conduct that's based on a person's membership in a protected class, as we just discussed. And it becomes unlawful when enduring the offensive conduct becomes a condition of continued employment. That's often referred to as quid pro quo, or that means this for that. So if you give me this, then I'll do that, or whatever the case may be. Or it's conduct that is severe or pervasive enough to create a work environment that a reasonable person would consider intimidating, hostile, or abusive. And that's generally referred to as hostile work environment. So allegations of hostile work environment harassment, those are the things that involve conduct. It can be verbal, it can be nonverbal, it can be physical. That's usually where we see name calling, slurs, jokes, gestures, leering, stalking, inappropriately touching or grabbing somebody, and even assault. When we talk about quid pro quo, we typically see quid pro quo harassment as allegations of sexual harassment. And I'm going to talk about that a little bit more next. So sexual harassment is a type of hostile work environment that exists when unwelcome sexual advances, requests for sexual favors, or other verbal, nonverbal, or physical conduct of a sexual nature occurs. And it can explicitly or implicitly impact the individual's employment, interfere with their work performance, or create an intimidating, hostile, or offensive work environment. So that's something that it is particularly sexual in nature. Quid pro quo sexual harassment, the this for that sexual harassment. That's when a job benefit, which can be employment, promotions, salary increases, bonuses, assignments, performance expectations, are made contingent on the person providing sexual favors. So that would be a supervisor, saying, if you go out with me, if you sleep with me, then I will give you a raise or something like that. Or then if you don't do it, then, something negative will happen to you. There'll be a detriment related to your employment. So that's the quid pro quo. You'll get a negative performance evaluation or something like that. So that's the quid pro quo sexual harassment. And I do want to share that because we are in an educational environment, sexual harassment is typically covered for most employers under Title VII of the Civil Rights Act of 1964. But in an educational institution, it's also covered by Title IX of the Education Amendments Act of 1972. And Title IX defines sexual harassment a little differently than you'll find in other anti-harassment laws. So under Title IX, sexual harassment means conduct based on sex. And it has that quid pro quo definition as the first one. The employee conditions, a provision of aid, benefit, or service on an individual's participation in unwelcome sexual conduct. The second part is that hostile work environment standard, that unwelcome conduct that a reasonable person would find to be severe, pervasive, and objectively offensive, that it effectively denies the person equal access to the education program or activity. I do want to highlight in the slide before, we talked about the conduct being severe or pervasive. So it's either really bad or it happens all of the time. Under Title IX, the standard is severe, pervasive, and objectively offensive. So it's a bit of a higher standard because you have to have those three things for it to be a hostile work environment under Title IX. And then Title IX also covers sexual assault, dating violence, domestic violence, or stalking. And it covers those things as they are defined in criminal law, and includes things like rape, sodomy, sexual assault with an object, fondling, incest, and statutory rape. So I just want to highlight that Columbus City Schools is covered by both as an employer, covered by Title VII and Title IX. So just want to make everybody aware that both of those things are out there, particularly when it comes to sexual harassment. And the definitions and the processes are a little bit different, for how complaints are addressed. So getting into complaints, how to file a complaint, and somebody asked about the form. So again, if you go to the Columbus City Schools webpage, across the top, hover over departments or click on departments and you find compliance, and you go to the compliance webpage. Again, on the left-hand side, you're going to see the laws that are covered by the compliance office. The last one on the list is the Civil Rights Act of 1964, it says discrimination and harassment. If you click on that, it'll take you to this page that I have a screenshot of for you here. And it says discrimination harassment complaint form. If you click on that link, it'll take you to the online complaint form that you can fill out. So when you're completing that form, if you wish to file a complaint and you complete the online form, it is always helpful for you to provide the name of the person who you believe has harassed you, and a description of what happened and when it happened, and whether anybody else saw it, or got the email or got the text message, or if there's video in the building, and who saw it, if there were other witnesses or other people who got the inappropriate photo texted to them. Whatever you can provide would be helpful. Then we would also want to know the reason you believe you're being harassed, which again is that protected category, such as your age, your race, your sex. And then it's also helpful to know what resolution you're seeking. Depending on what it is, it may or may not be something that we're able to do. Like if you want the person to be fired, I can't guarantee you that will be the outcome. But if that's what you're seeking, feel free to let us know, so that we consider that as we are reviewing your complaint and doing any investigation. And as with the accommodation request form, once you complete the online complaint form, you'll get an email that has a copy of your complaint that you can keep for your records. And I also do want to share with you that if you have additional information that you want to provide, the complaint form does allow you to type in quite a bit of information. But if you have, like I said, copies of text messages, photos, emails, or you have been documenting something that's been happening to you and you have it in a Word document that you've been keeping, and you would rather send that, well, in addition to the form, it's always helpful to get the form and all the information on the form. But if you have additional documentation that you want to submit, you're welcome to email that to us. It's always helpful to have the information about what's going on, any information, any supporting documentation that you have. We will obviously gather some documentation and information as well, but whatever you can provide so that we get a good picture of what's going on is always helpful. So you filed a complaint, so now what happens? So when you file a complaint and it's received by the compliance office, we'll review it. And we may have some questions. So we'll reach out to you by phone or by email, and may request some additional information from you or some clarification if something's not clear. We may ask for some additional information. And then after that, we'll notify you about whether or not your complaint has been accepted for investigation. There may be times where you fill out the complaint form and something's going on, but maybe it's not really related to your membership in a protected class. So maybe that wouldn't be something that we would investigate, but maybe that's something that you could pursue with human resources. So we'll try to give you some information about who you might talk to about the concerns or issues that you're having, if for some reason we're not able to, if we don't have the jurisdiction to investigate it. If we do accept your complaint for investigation, I do want to make you aware our policy does provide that the person who you filed the complaint against be notified, and they have an opportunity to respond to the allegations, and they have an opportunity to provide supporting documentation, for whatever their response is. And we also may conduct interviews with witnesses and otherwise gather documentation from other areas. You know, if you tell us there are witnesses or we know who's in your work unit, you know, we may talk, depending on what the allegations are, we may talk to different individuals to see what their experience has been, what they've observed. And again, gather documentation, again, depending on what the allegations are and what you're telling us is going on. Once we complete the investigation report goes to the superintendent. The superintendent actually will make the final decision as far as the outcome of the investigation. And you will then receive a copy of the final decision and the investigation report. And again, because I did mention that whoever you file a complaint against does have an opportunity to respond to the allegations, do want to share that anti-harassment laws and CCS policy does provide that you cannot be retaliated against for filing a complaint. And anybody who you indicate has witnessed the conduct, you can't be harassed or retaliated against for participating in an investigation as a witness either. So we do make it clear to the person who's responding to the allegations that they are prohibited from retaliating against anybody who's participating in the investigation. And if that were to occur, there would be consequences for the retaliation, even if we were to find that the underlying harassment complaint wasn't substantiated or founded, whatever terminology you want to use, but then the person retaliated against someone for filing a complaint, then there could still be consequences then for the retaliation, even if like I said, there wasn't sufficient evidence to substantiate the underlying claim of harassment. So just want to make sure everybody's aware of that protection. And that was everything that I had on harassment, just sort of the general information and how to file a complaint. Same as with accommodation requests, any questions you have can be directed to the compliance office. That's our contact information. Again, we do have a different email mailbox for those types of questions, but that information is displayed for you. And again, I'd be happy to take any questions, comments, concerns that anybody may have and want to share.
Awesome. At this point, I think you've already answered this question, but I do want to make sure, just in case it was missed on the person who asked, can anyone file a harassment complaint, or does it have to come from the person that is happening to?
Anyone, thank you, that's a good question. I didn't answer that. Anyone can file a harassment complaint. So you can file it as a third party. It doesn't have to be happening to you. If you are observing it happening to somebody else and you are concerned about it, you can file a complaint as a third party. Yes.
Awesome, awesome. Also in the chat, there are a couple links that I placed in there to hopefully help you easily navigate to those sites that were mentioned earlier. There was an earlier one that takes you to the compliance page. And then the most recent link was to the civil rights page and the actual harassment form, in case that is something that you were looking for. So that is still available online, but you just have to do maybe a couple more clicks to get to that. Let me make sure there's no more questions. If there are any questions, we have until 11:15, so we have approximately 10 minutes. If there's anyone who has a question or a comment, if you would not mind raising your hand on the on your tile, and maybe Aisha, if you stop sharing, then we can be able to see anyone who has a question. And this is a good time to ask regarding reasonable accommodations or harassment. And if you have any suggestions on next step training, this was ground level, just because everyone, we want to make sure that on the baseline, everyone understands what reasonable accommodation is, how it's defined, how it's separate from other things like FMLA, and then also harassment. We just wanted to give like a baseline. So if you have any suggestions or ideas or comments about what you would like to know going forward, we can certainly create content and provide professional development to suit that.